Good evening and welcome to Slam the Gavel, the show that tells all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. This episode of Slam the Gavel is sponsored by CPS Protect Consulting Services. Child Protective Services cases are among the most frightening experiences any parent can endure. Don't face them alone. With urgent assist by CPS Protect, you get the peace of mind to raise your children as you see fit, and the personalized assistance of their team of expert child welfare consultants, former CPS investigators themselves, right when you need it. Get started absolutely free at cpsprotect.com/register. Also, go to the site, pleasedoyourjob.com. We need 2,000 more signatures to get a very important case reopened. That's pleasedoyourjob.com. I have a return guest on. I have Brian Vukadinovich back on, and he was last on the podcast season 4, episodes 69, 99, and 119, and season 5, episodes 13, 37, and 44, as well as 74. And I welcome you back to the podcast because we've got some updates and this rogue lawyer writing a letter to get your case dismissed. So I welcome you back.
Hi, Marianne. Great to be back. Thanks for the invite back. You have a great show, and you're doing a great job in alerting the people around the country as to just how serious of a problem we have in our judiciary system all across the country. So you're doing a great job, and it's always an honor for me to come back on here and spend some time with you and hopefully educate the public a little bit about things that the public needs to know in terms of judicial corruption, because there's a lot of it going on. And there's things going on right now in my case against former Judge Richard A. Posner. There's a breach of contract case that I filed against him because he refuses to pay the money that he owes me for working for him. And he's hired, he's got a bunch of lawyers in Indiana and New York and Chicago battling me with a whole lot of nonsense that they're playing games with. And there was a situation earlier when they were trying a defense of legal incapacity that they're saying that the judge had because of some illness, which they have not proven. They have not brought forth one item of evidence whatsoever to prove. They were saying, his previous lawyer said that he didn't have the legal capacity because of some illness to enter into a contract in 2018, which was nonsense, and they know it. And then now they have shifted their strategy somewhat, and now they want to argue statute of limitations in the case. And then there's some very shady things going on with his lawyers. He's got several of them, and in particular, he's got this one lawyer. His name is Justin M. Ellis, and he submitted an affidavit in the case on November 16, 2023, trying to support this nonsense argument about statute of limitations. They want to try to get the case dismissed, trying to argue that I waited too long before I sued him and so forth.
This is typical.
Yeah, it's just a bunch of nonsense. These guys, I mean, the stuff that lawyers get away with in the courts, it's just absolutely mind-boggling that courts allow that garbage to take place. He stated in his affidavit, and he filed it formally in the case, quote, now these are his words, not mine. He said, a search of the Gmail account shows that plaintiff last sent an email to defendant on May 21, 2019. Now, the audience might be thinking, well, what's the significance of that? The significance of it is he wants to falsely argue that the last time that I requested payment was on May 21, 2019, and I waited to file the lawsuit until 2022, and therefore I waited too long, and now we have a statute of limitations. But unfortunately for him, he's been caught in his own lie because I have an email that I sent to Posner in November of 2020 asking for payment for my services. And therefore, what he stated was blatantly false. And then when I sent that email in November 2020, and I filed a lawsuit in 2022, that puts me within the statute of limitations. So he got caught red-handed with his lie on his affidavit. And it's, by the way, it's a federal crime. When you lie on an affidavit in court, there's a federal statute that you can be fined and you can go to prison for 5 years or both. So I filed a motion for sanctions with the court. I submitted his false email statement, and I asked the court to refer the matter to the United States Attorney's Office. So right now, nothing's happened yet. We'll have to wait and see if the court actually decides to do anything with it or if it gives them a pass. So we'll have to wait and see. So he tried that little tactic, and it didn't work. It backfired. And then when we had a hearing in December, and I brought when I discussed his affidavit, and I told the judge, it was a straight judge, Kohler was his name at the time. And then I brought out the email, a copy of the email that I actually sent in November 2020. And the judge didn't really want to have anything to do. It's too bad, we're done here. Okay, he abruptly held it, dismissed the hearing, called the hearing off abruptly. And then I asked him to take judicial notice of the email, and he wouldn't. And then on the way out the courthouse, the marshal approached me and told me that the judge wanted us back into the courtroom, which was very strange after a hearing has already been adjourned. So we go back in there, and then this magistrate, Kolar, then he said, well, I had an opportunity to read the email in chambers, and it appears that the email supports the plaintiff's position on statute of limitations. And then Ellis now is going bonkers. Oh, well, I never saw that email before. The plaintiff never produced it to me before. How do I even know it's authentic? All of that nonsense. He knows well that email is authentic. He knows it. All of that nonsense. And then, so then the judge told her, well, did you provide a copy of the email to the defendant's lawyers prior to today? And my answer was no, because I didn't have to, because I did it under a judicial notice. And when you file a motion for judicial notice, the only requirement is when you file the motion, you have to provide that information at the time you file it. We were not in discovery. I had no obligation. I don't have an obligation to provide information of wrongdoing on the part of the defendant's lawyers ahead of time to them and show them in advance. If they choose to lie about information, that's on them. I have no obligation to help them with their lies.
Right. It's shame on them.
Absolutely, 100%. And then if that wasn't bad enough, then this Ellis, as desperate as he is now, okay, if that wasn't bad enough, now we have a new magistrate now, because Kolar now is on the Seventh Circuit. So now we have this new magistrate. His name is John E. Martin. Okay. So this lawyer, Ellis, on March 8th, 2024, lawyer Justin M. Ellis sends a letter to Magistrate Judge John E. Martin, and here's what he said. Now, these are his words. This is the letter. The law firm Molo Lampkin, Justin Ellis's signature on the letter right here. He says to the judge, quote, at the same time, we respectfully ask for this court's assistance in discovery to help bring this case to a swift end. So we're at a point now in federal litigation that unsavory lawyers can write letters to judges and ask judges to help them with assistance to bring cases to a swift end. Courts are supposed to be neutral.
And he sent you a copy of this?
Yeah, he had to, because it was filed. He filed it in court, so you have to provide the other side with a copy of it.
Right.
So that's how he did it. But it was really
that's
strange
stupid
and unusual, because normally you don't send letters to the judge.
No.
You do it by motion. You
Right.
file pleadings, and then the other side has an opportunity to respond to the he did this by letter. He actually wrote a letter to the judge, which was very, very strange and unusual. And I mean, it's right there. It's right there. Hey, we represent Posner, a famous federal judge. And that's how the case started out at the very beginning. They reminded the court right off the bat, and hey, now remember, now this is Richard A. Posner, a federal court of appeals judge, 36 years.
Let's all genuflect.
100%.
Ugh.
And then he asks in his desperation, because he knows he can't win this case legitimately. They know if this case goes into trial, what I'm going to do to them with the evidence in this case. They all know it. The lawyers know it, and the judges know it. And there's a major effort going on as we speak right now, as he said, to put the case to a swift end. Because if they can convince the judge to help them and assist them, as this lawyer Ellis is asking the court to do, then there's no jury, there's no public trial, and then all of the corruption that took place with the breach of contract, and there's a lot of other things that come into play in the case. They have actually lied to the IRS, Posner and his lawyers and his compadres. They have actually filed lies with the IRS, stating certain lies to the IRS, that no employees were paid a salary, which is a blatant lie. Because, and I documented that. It's right in the case. It's documented. And there's also a question as to what happened to the funds that were donated to the Posner Center by the public. This Ellis is arguing, oh, we, take our word for it. This is what happened and everything. Well, you know what? I'm not taking their word for it. I want to see the evidence of what happened to that money. Who received the money that came in from the public? Who cashed the checks? What did they do with the money? What happened with the money? And who received the money? And what did they do with it? And at the trial, all of that will come out. We don't know what happened to that money. They're claiming that only $20,000 and something was donated, but that's still a lot of money. Now, Posner stated that he thought he could get over $1 million in donations. So we need to figure to see in the case exactly how much money came in. Because I'm sorry to have to say this, but when you get a tub of money and you surround a bunch of lawyers around a tub of money, that money is going to vanish real quick. And we need to know what happened to that money. So if they could put this case to a, quote, swift end, like Ellis is asking for the court to assist him with, then all of this stuff doesn't come out. And sadly, we're in what's called bifurcated discovery, which is something very strange and unusual. Kolar, now early on in this case, they filed a motion to dismiss. And after 13 months of waiting for a ruling, I won the motion. It wasn't dismissed. And then we were supposed to begin discovery from that point. So after waiting all that time and actually defeating their motion, they tell the court, oh, well, we're going to file another motion to dismiss the case. So Vukadinovich shouldn't get any discovery. He should now have to wait again now until that motion. So I argued against that. What do you mean I have to wait again? We're already several years into the case now. So this Kolar, he gives it to them. They can do discovery against me, but I can't do discovery against them and get the information. Then this new guy now, Martin, we had a telephonic hearing not too long ago, and he rubber stamped Kolar's ruling. We're staying with the bifurcated discovery, which means Posner gets discovery against me, but I don't get discovery against him. So I asked Martin, could you explain why you are not willing to follow the precedents from this division? There are several precedents that I cited from this very division that state that bifurcated discovery should not take place in this division. But yet, even though that is the precedent from this division, these judges, in my case, they don't want to follow that precedent. They want to allow only discovery for Posner, but not for me. In other words, I don't get to get the evidence to put the goods out there to show the evidence of the corruption that's going on. And right now, this court is accommodating them. Now, the judge here, her name is Teresa Springman. We'll have to see. I've got papers filed. They're on her desk as we speak, and she certainly likes to take her time with rulings. And we need to get things sped up here, because the case law is there are also public policy elements involved in the case. The case law is that because there are public policy concerns, that discovery needs to take place for those things as well. So in addition to my actual breach of contract, there are public policy concerns regarding the lies that Posner and his compadres submitted to the IRS. We need to know about the money. The public has a right to know what happened to the money that came up. You know, all of a sudden there is no money when the Posner Center dissolved. The public has a right to know that under public policy concerns. But this court has chosen to ignore the public policy concerns, the case laws that require adjudication of public policy concerns. And we all know why. Nobody was born yesterday here. They are protecting Posner because he's a former federal court of appeals judge. He's got all these lawyers now filing false information on affidavits, writing a letter to the judge. Help us, help us. We need assistance. Help us put this case to a swift end. It's just ridiculous. It's just absolute. The fix is in as we speak. Yes, I'm going to say it. The fix is in. Now, this Ellis, he's got a big problem with the information that I've been disclosing, that I've been revealing to the public. He's been filing court papers against my interviews. In fact, he has actually cited you as a witness in this case because of the interviews that we've done. He's taken issue with my books that I've written, with my interviews. He put a copy of my recent book right in the case, put a copy of that. And
wow.
Look, all right, now.
I hope he put a copy of mine because you wrote the word.
Well, you know, if he puts you on the stand and he's got you listed, we'll certainly talk about, you know, when you get on the stand, we'll certainly talk about, you know, your involvement and how you know, are out there exposing judicial corruption and the importance of these interviews that we do.
Oh, yes.
So it's going to bite them in the hind end for sure. And can you believe now I'm going to hold this up here now. What I'm holding up here now, you can see these are hundreds and hundreds, possibly thousands of pages. And I'm going to tell you what these are. As I'm flipping these, Ellis filed all these in the case. These are the interviews that you and I have done. These are screenshots, and these are postings on Twitter about our interviews. As I flip these pages, these are screenshots of our interview. And he is so obsessed. Justin Ellis is so obsessed with me. And he knows, and you as well, because now he wants to have you as a witness in the case as well. And you know what I say to that? I welcome that. Let him have at it. I will not object to that. He is perfectly invited by me. I will not object to having you come in and testify at the trial. But this is the nonsense. Let's stop Vukadinovich and Marianne Petrie from discussing judicial corruption in the courts. And even though this is a breach of contract case, let's bring in let's bring in the First Amendment issues of Vukadinovich and Marianne in disclosing public corruption in the courts.
Mm.
He's desperate. He's obsessed with this, and he knows the only chance he has to save face is if the court will do what he asks, to help him, to assist him in bringing the case to a swift end. That's the only chance he has.
Why doesn't he just use his head and go back to Posner and say, hey, with all the money you're dumping into all these attorneys, why don't you just rightfully pay Brian Vukadinovich what you said you were, and you know, you'd be farther ahead, right?
Yeah, well, my guess is there are two reasons for that. One, he's on a major ego trip. I'm going to be the one that's going to bring Vukadinovich down. Okay, he's on an ego trip. You know, he's out there doing all these interviews, and now he's, you know, putting all that into the case and so forth, like it's supposed to somehow intimidate me into not discussing judicial corruption any further, which is really foolish on his part if he's that stupid. I mean, he's really stupid if he
Oh,
thinks
yeah.
that type of intimidation tactic is going to work. And also money. He gets, you know, money for this, you know, as long as he can convince, you know, his clients, hey, I can win this case, you know, you don't have to pay any money, let me proceed here, you know, and then so, you know, he gets money too. So, you know, these guys are on ego trips, they get money, they're on ego trips, it's sickening. I'm going to tell you something else that's very disturbing in the case. This is extremely disturbing.
Well, there's a lot disturbing in your case as well as mine.
100%. You know, there's a guy, his name is William Bond. Okay. He has written several emails, ex parte emails to the court, to Judge Springman and to Magistrate Judge Kolar while Kolar was still there. He wrote several of them. I believe there were 4 of them. And then he wrote a 5th email that he actually sent to all the parties. So in other words, that one wouldn't be ex parte. But the 4 previous ones where he just sent them to the court without sending a copy to the parties, those were all ex parte emails. So he told the court that he is a close, now this is his word, not mine, friend of Posner, Richard A. Posner, and his wife, Charlene, and his sons. So now this guy is telling the court they need to rule in favor of Posner. He said, hey, I know Posner, we're close friends. And now listen to this. According to an opinion by the U.S. Court of Appeals for the Fourth Circuit, William Bond, this person who wrote these ex parte emails in this case, he was formerly known as William Rovtar. He pled guilty to beating his father to death with a hammer in his grandparents' garage in Ohio.
Oh, that's creepy.
And then he wrote a book. The book was titled Self-Portrait of a Patricide, How I Got Away with Murder. And the book was about how he planned and committed the murder of his father with a hammer, and how his dying father attempted to raise himself off the floor of the garage before Bond delivered the final blows to his neck and the head, and then he stuffed his father's body into his car's trunk. This all came out of this opinion out of the U.S. Court of Appeals for the Fourth Circuit. And they talked about some other things that he did. He was shaking down his future father-in-law for money and so forth and threatening him. And he claims to be a close friend of Posner, his wife, and his sons. Now, when I responded to that email to the court, Posner's lawyers responded and did not deny that Posner is in fact a close friend of this murderer, as he stated in the email. Posner has never denied that. His lawyer said, oh, just disregard the email. What do you mean disregard the email? This guy is a societal misfit.
Uh-huh.
He's sending ex parte emails. He murdered his father, bludgeoned
God.
him to death with a hammer, and now he's demanding that the judge dismiss this case in the case. He sent 4 emails to the judge, ex parte, and a 5th one. And then, now, you know, this is very concerning. I mean, with all the stuff going on around the country with these mass shootings and so forth, we
Mm-hmm.
can't have a societal misfit. Like, I asked the court to do something about this guy. This court won't do anything. They won't stop. They won't put an order out stopping his emails. They won't. You know, he actually needs to
Well,
be referred. But we don't know what this guy. What all we know about him is he's a murderer. We know that.
and
So what I'm
his
concerned about
emails
is
his emails are harassment. Why is he sending?
100%.
Yeah.
And on top of that, he's making legal arguments in the case for Posner. He's not a lawyer. That right there is against the law. And my question is, why is this court unwilling to take action against this guy, this murderer who is
Mhm.
sending in these threatening emails? What are they afraid of here? What's going on here? Why are these judges in this case protecting Posner, won't let me have discovery? They know that the discovery is going to show that his defenses are a sham. They know the discovery will show that. These judges absolutely know that. These judges know that the discovery will show evidence of the lies that were committed on the IRS and probably
Mhm.
problems with the money that is gone now that was donated in. And now we get this letter from Ellis to the judge: help us, assist us in putting this case to a swift end. Well, I'm going to tell you something here. If this court chooses to play along with this, uh, there's going to be some public revelations about just how corrupt we already know how corrupt the judiciary is and can be. And if this court now plays along and ends up dismissing this case, the country's going to hear about it for sure.
Mhm.
And if Ellis thinks that him posting all of these screenshots of my interviews, my and your interviews, and his criticisms of my books and so forth, is somehow going to have some kind of an intimidating effect against me, he's very, very wrong,
Mhm. Mhm.
just to say the least.
And a bully
Uh,
and uh,
Trying to be a bully.
right.
Absolutely. Oh, and by the way, if I could add in here another tactic that Ellis is just using now, just recently. He he got an affidavit from this lawyer in Chicago. Her name is Sakina Carbide. Okay, she's a immigration lawyer in Chicago. Sakina Carbide. So on February 16th, 2024, Ellis and the other lawyers, there's several other lawyers involved in the case, they filed this affidavit by Sakina Carbide. She was one of the volunteer lawyers in the Posner Center. Okay, she she was at some meetings. She had some participation in some things that we were doing in the Posner Center, and then she came to a lunch with me in Posner, and so and Posner met by ourselves. We discussed some business of our own regarding our contract. And then this lawyer, Sakina Carbide, she then became a member of our lunch that day. Okay.
Mm.
Now, she was not there during the time when Posner and I discussed our business dealings regarding our contract and so forth. That's none of her business.
Mm-mm.
The contract between me and Posner is between me and Posner. It was a private contract.
Mhm.
So she files an affidavit with just numerous lies. Posner never said this. He never said he was going to pay Vukadinovich, and all of this and all of that. He never. Not only did he never say it at the meeting at the lunch meeting, but he never ever said it. Well, how can she possibly say that he never said it at the meeting when she wasn't there at the complete meeting, and that he never ever said it ever? How could she possibly even say that? And now, so they recruited her. She's a Confederate. She was recruited clearly by Ellis.
Mm-hmm.
She signs this document, and get this. She says in several places in the affidavit, she says, she talks about at the March 19th meeting that she said that that Posner never told me about the salary I was going to receive and all that kind of stuff. Then at the end, she says, quote, now these are her words. This is her affidavit.
That's a long one.
It's 8 pages.
Oh, brother.
It's her signature. And then she says, and she said this in several places in the affidavit, I am certain that he would have discussed it, or at a minimum disclosed it to me, due to my involvement with the Posner Center and due to defendants' trust and admiration of my work. So she was so full of herself. Oh, Posner would have disclosed all of that information to me because of how my involvement and due to his trust and admiration for my work. Okay. Well, guess what?
Well, it's like methinks she doth protest too much. Why would she do an 8-page, looks like a brief, and just do a 1-page affidavit like everybody else?
Well, they wanted to get in as many lies as they could.
Well,
now,
it looks bad to have an 8-page affidavit. It looks like a brief.
Well, exactly, because let's build this up as much. Let's get as much in there as we can. Let's try to slant this court to help us and assist us in how they're asking the court. And guess what? She, just 1 second here. Let me tell you how much credibility she has.
Oh no.
Oh yeah, oh yeah. He, first of all, let me show the evidence of what Posner really thought about her. Now remember, because of how he trusted her and admired her, that he would have disclosed to her at a minimum all of the things that. So here's what Posner. Now, this is an email from Posner to me. Okay. This is not my words. These are Posner's words. Okay. This is him talking about Sakina Carbide. Okay. Here's what he says to me. This email is dated February 25th, 2018. Here's what he says. Brian, do you have any idea what she's doing? I don't. She sent us 2 blue pages of revisions of the petition for cert, plus a fine print draft revision of the entire petition in 23 pages. She wants the 3 of us to get together and do what? She doesn't write intelligible English, and I think with her suggested changes, the probability of the Supreme Court's granting cert falls to 0. So, trust and admiration in her work? Posner himself says she doesn't write intelligible English, and with her suggestions, the probability of the Supreme Court granting the petition falls to 0 with her involvement. And then he says, towards the end of the email, quote, and to think I appointed her regional director for Cook County, exclamation mark.
Oh,
that's a far cry from her stating that, oh, because of Posner's trust and admiration for her, that he would have disclosed all these things to her. So I filed this in the case. The judges have it.
Mhm.
But you know, her credibility as far as her affidavit, there's some big problems here because she tried to sue. She had filed a lawsuit previous to this.
Mhm.
She tried to sue a person for $177,250 at a rate of $400 per hour. She was trying to, there was a person, couldn't speak very good English,
Mm.
and needed some help. And the court, and then she filed this lawsuit in Cook County Circuit Court in Chicago. And now they took her to task. They asked her about her billings, and she couldn't justify her billings.
Mm-mm.
And then after an intense evidentiary hearing, the court found her testimony and affidavit not to be credible and ruled against her. Okay. And they stated that her testimony and affidavit, the Illinois Court of Appeals reviewed the trial court's decision in the case when it denounced her credibility and her affidavit, and stated that her testimony and her affidavit, quote, is not well taken. That was already decided by an Illinois court. Sakina Carbide's testimony and affidavit, the credibility is not well taken. So I have filed all that information for the judge here for Springman and this Martin to see, and I have asked
Mhm.
for an evidentiary hearing now in this case, just like they did in Illinois. Now,
Mhm.
his lawyers with Ellis, they're all resisting it. They don't want to have this evidentiary hearing. They don't want to let me put Sakina Carbide on the witness stand under oath and question her about the statements that she made in this affidavit. That's the skullduggery and the chicanery that goes on with lawyers. They'll
Mhm.
put lies into the case, and then when it comes time to actually show up and defend their lies, they don't want to do it. They want to
Mm.
fight against it. They know what I will do
Mhm.
if the court grants my request for an evidentiary hearing. They well know what's going to happen when I put this Sakina Carbide on the witness stand. But remember now, Justin Ellis lies himself on his own affidavit about, oh, a plaintiff never sent an email after 2019, which was false. Then he turns around, sends a letter to the judge, help us, assist us, putting this case to a swift end. Then he recruits this Sakina Carbide. She puts in a bunch of lies on an affidavit.
Oh.
And now let's have an evidentiary hearing. And now he wants to fight that as well. He knows the problems they have with this case
Yeah.
and what I'm going to do to them. He knows it. The other lawyers know it. These judges know it. Let's get this thing into a trial. What are they afraid of? That's what's happening here.
Yeah, because the fix is in.
100%. Now, I have no doubt that this interview that we're doing right here now, as we speak, that Ellis is going to take screenshots of this, and he's probably going to add this into the case and all of this and all of that.
Right.
And you know what? Have fun. Have fun, Justin Ellis, because I have a First Amendment right. This isn't just about my case. This is about corruption that goes on in the judiciary. I
Mhm.
have a First Amendment right. Yes, I write books. I write articles about
Right.
these things. I do interviews. And if you don't like it, then go to some third world country where they don't respect the First Amendment and practice law over there. As long as you're going to be here in this country practicing law here, if you can't respect a person's First Amendment rights, you're in the wrong profession. I'm sorry.
And his mother should be ashamed of him. I'm sure. I hope she raised him to be a better person than this.
Well,
Oh,
that's
I don't know.
that's
I don't know.
we don't know, and clearly what he's doing is shameful. It's a disgrace. It's a disgrace to society as a whole. It's a disgrace to the judiciary, but the judiciary just kind of lets those things happen. Uh, it's going on all over the place. And then when somebody comes along, like myself or yourself, and we're out there and we're revealing it to the public, they get all up in arms about it. They don't like it. And
Mm-mm,
then
mm-mm.
how they fight us, they'll bring in lies, and hey, we're going to bring in all these lies, but we're not going to let Vukadinovich in court confronting us with these lies. Okay, now that ought to say something right there.
Right there.
If,
Yep.
if Sakina Carbide's affidavit is on the up and up, then what are you worried about? Why would you not want her to testify at an evidentiary hearing? What are you worried about then? Because they know what's going to happen. What are you worried about at a trial? If you have all of these defenses, then let the jury state your case to the jury. They know what's going to happen. They know what will happen at a trial when I put witnesses on the stand and Justin Ellis and these other lawyers are sitting there. They're going to watch me expose the absolute corruption that they're bringing into this case, the sham defenses that they're bringing in here, the lies that they have submitted in this case in a lot of different ways. They know it, and the judges know it as well. So if this case gets dismissed, as Ellis has asked for help and assistance in that letter to the judge, well, the country is going to have a real good idea about what happened here.
Oh, definitely.
I mean, this is they're protecting. They're protecting. I'm going to tell you, the do we have a couple of minutes here?
Sure, yeah, because I don't want to keep you all afternoon because you know I could.
Well, the sad thing here is, hopefully you would think, if the guy did the work, pay him, okay? But
Right.
that's not, they don't want to do that. So now they want to assassinate my character because I'm out there exposing judicial corruption and I'm exposing their lies that they have submitted in this case. So now they want to paint me to be like the bad guy here, that Vukadinovich is lying and so forth. Well, you know what? Let's have a trial and you can state it to the jury and let's see who the jury believes here. Now, if you want to talk about lies, okay. Now, I'm sorry to have to say this, okay, but like the defendant in this case, Posner, Richard A. Posner, and this is all I brought, I documented all this in the case. If Ellis and his lawyers want to talk about lies, well, here's Posner's lies, okay. Before this case was, he'd been lying from the get-go when he took his oath of office to be a federal judge. He had to swear to perform all duties under the Constitution and laws of the United States. He had to swear that he would do that, okay? So he told the New York Times, quote, I pay very little attention to legal rules, statutes, and constitutional provisions and Supreme Court precedents. And, quote, when you have a Supreme Court case or something similar, they're extremely easy to get around. So after swearing that he was going to uphold the Constitution and the laws of the United States, he tells the New York Times, I pay very little attention to the legal rules, statutes, and constitutional provisions. Well, that's a lie then, when he took his oath.
Right.
Okay. Now, The Hill published a piece in July 2016. Here's what The Hill said, quote, by laying bare his contempt, they're talking about Posner, by laying bare his contempt for the Constitution, Posner violated his oath of office and permanently stained the honor of the federal judiciary and suggested that, quote, Posner quietly resign his seat to a more fitting occupant. The Hill suggested that he should resign because he violated his oath of office. Now, Posner stated in a YouTube presentation in September of 28, the presentation was titled, get this, quote, let us never blame a contract breaker. The irony of that in this case, the presentation that he put on was called, let us never blame a contract breaker. Don't blame the contract breaker, as he is in this case. Okay. And here's what he said. He said in the interview, he doesn't want to see, quote, moral reasoning brought into contracts. And he also said in the interview that judges are, quote, confused by, quote, moral language.
Oh my.
And he told, and 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 it's just it's just unbelievable.
Oh,
And he told the he told the he told Law 360 that he was disinvited to a Seventh Circuit dinner because of animosity between himself and the other judges. Now, get this. On July 10, 2017, Chief Judge Diane Wood sent a letter to Chief Judge Rebecca Smith of the Eastern District of Virginia, who chaired the Judicial Conference Committee on Codes of Conduct addressing ethics concerns about Posner. Shortly thereafter, Posner was informed by the Judicial Conference Committee chair that what Posner was attempting to do, quote, ethically should not be done, and quote, the committee cannot make its decision in this regard any more clear. Posner was trying to go outside the bounds of some kind of rule that he was supposed to be following at the Seventh Circuit, and Wood told him not to do it. The Chief Judge Wood told him not to do it, and then she turned him in, and then he was reprimanded by that committee. And Ellis
wow.
and those other lawyers, they want to portray me to be the person that's lying about all of this and all of that. Their own client Posner lied when he took his oath of office and was suggested by several media. It wasn't just the Hill; there were several other ones that he should step down because he violated his oath of office, and for him to publicly state that he pays as a judge. This was while he was a judge. He said, I pay very little attention to legal rules, statutes, and constitutional provisions and Supreme Court precedents. And when you have a Supreme Court case or something similar, they're often extremely easy to get around.
Mhm.
In other words, he basically was bragging, we do whatever we want to do. That's not fair to any litigant. When you have a case and it's in front of Posner, he was duty bound to follow the statutes and the Constitution, and he publicly boasted that he didn't do that. And then he turned around, he entered into an agreement with me to pay me money for services to him, and then he basically got slave labor from me, and now he's in court with Ellis and all these guys, bringing all this nonsense into the case, and they want this judge to help them, to assist them. Those are Ellis's words, to bring the case to a swift end. That's what's going on in this country. And it would be shameful for this court now to play ball. I've addressed all this. This Judge Springman, she has all of this in front of her. Now, judges get creative. Whenever they decide to, that they want to go one way or the other, they get creative, just like Posner said there, things are easy to get around, precedents are easy to get around. They don't want to follow the precedents here. The precedents here, we're not supposed to have bifurcated discovery in this division. These judges in this case are allowing it, so Posner doesn't have to produce the evidence and so forth. So that's what's going on. This case is Exhibit A of how when a case is being fixed, how that's done. And that's exactly what's happening here. We have false information submitted by the lawyers. We have false information submitted by another lawyer, recruited by these lawyers to bring in lies to the case, and so forth. And we have judges that are not willing to follow the very precedents from this very division. So if that's not being a case with the fix being in, I don't know what is.
Yeah,
And that's exactly what's going on here. Now, Ellis is going to file this, and if the judges want to have any questions to me about these interviews, this interview or any other interviews, they can have at it.
Right. And there is the 10 Commandments, thou shalt not lie. And in my opinion, lying is worse than murder. So, they also have to answer to God, and God will deal with them. I have a track record with that and watching God's miracles. So, but I'd like to have you come back on.
Well, I'll certainly be happy to, Marianne. I mean, we got, there's a lot of other things. You're dealing with a lot of other people around the country with cases, particularly in family court cases around the country that we've become familiar with. I've got myself familiar with some of the cases and some of the people that you talk about in your great book here, Lee Grenade and Adrienne Miranda and so forth. And so I think down the road we're probably going to be doing a podcast or two about some of those cases, what's going
Oh,
on.
yes.
We deserve to be treated right in this country by the judiciary. This shouldn't be all about lawyers getting away with all the nonsense that they get away with, the lies that are taking place. Judges should clean up the courts, what's going on.
Mm-hmm.
These cases should be decided on the truth and not lies by lawyers and witnesses that lawyers recruit to come in and lie, just like they've done here in this case here. As again now with Sakina Carbide, what's your problem? Why not have why are you opposed to an evidentiary hearing? If all of her statements were true, like she said, then you should have nothing to worry about. But they have plenty to worry about, and they know it. And so this judge needs to set it for an evidentiary hearing, and we need to discuss. There's a terrible problem going. Since you and I became acquainted, and I started learning more about the family courts, what's going on, and it's just horrendous. So we'll be shining a light on some of that stuff as well down the road.
Oh, yeah, I'm so glad to have met you, but don't jump off. In fact, I'm going to put all your contact information in the podcast notes. So if you want to reach Brian Vukadinovich, you can go to motion4 justice at yahoo.com, and on Twitter at motion4 justice. And also www.brianvukadinovich.com. But hey, don't jump off. Salam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, Cry Out for Justice, Poems of Truth, and Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. You can find me on Spotify, YouTube, Apple iTunes, Anchor FM, iHeartRadio, and feel free to buy me a coffee to help keep this podcast going. And that will be in the podcast notes. And all you lawyers watching this, I ask you to, contribute to the podcast so I can help keep it going. And I thank you, Brian Vukadinovich. Thank you so much.
Thank you, Marianne. It was an honor being on here with you.
Thank you.